In this lecture, I'll be discussing ethical practice. In my experience, when students who are in training to become mental health professionals start to discuss ethics, their initial thought is that it's going to be all about memorizing ethical codes and laws. So they believe that as long as I'm following the ethical code of my professional organization and I'm following the law, then I'm behaving ethically. But these laws and these ethical codes really represent the minimum standard of conduct. So this says, as long as you follow these rules, you won't get in trouble with your professional organization or in trouble with the law. But really, this is not providing the best standard of care for your client. You'll want to go above and beyond those ethical standards. And you'll always want to have in mind what is in the best interest of the client. So not solely what meets that minimum standard of the ethical code or the law, but what is in the best interest of the client. Ethical principles will vary from one professional organization to another, but there are several principles that all of these organizations have in common. These are things like non-maleficence, so doing no harm to your client; beneficence, doing good for your client; respect for autonomy and self-determination. Your client is autonomous, they have the ability and the right to make decisions and determinations for themselves. This is why we engage in things like informed consent, because your client has the right to know what to expect from therapy and to either agree to that or not agree to that. Justice and fairness. So we don't discriminate. We advocate for social justice, for the fair distribution of resources and opportunities. So you seek to not discriminate toward your clients as individuals, but also sort of try to address societal injustices. Fidelity. We are trustworthy. We are in a trusting relationship with our clients. So the client can trust you to be competent in the interventions that you use. The client can trust you to have his or her best interest at heart. And veracity, integrity both have to do with truthfulness and doing, saying, being who you say you are. Okay, so we are not going to get into an exhaustive discussion of professional ethics in this particular class and this particular lecture, because either you have already had a full course on ethics or you will have a full course on ethics. So I don't want to repeat a lot of that information, but I am going to focus on the ethical principles that speak directly to the basic counseling skills we're learning in this class. So we're going to be talking about informed consent and the informed consent process and the process of documentation. So when is informed consent carried out? It should take place as early as feasible in the therapeutic relationship. And informed consent goes beyond simply, having the client sign off on a permission slip that says they agree to therapy. This really is an educational process where you educate the client about what to expect, how the process will go, their rights, and then give them the ability to either agree or disagree and decline to enter into that relationship with you. So things that are typically included in an informed consent document. So the kind of services or treatments being provided, the risk and benefits of treatments. So you want to discuss things with your client like the fact that they may feel worse before they feel better. That would be a risk of treatment. Benefits could include things like improved relationships, improved self-esteem. So you want to talk to them about any risk of the therapy and possible benefits of the therapy. You'll want to inform them of things like the length of the visits. So if they're booked for a 1 hour visit, does that mean that they'll be with you for the whole hour? Or are you going to see them for 45 minutes and then use that last 15 minutes for documentation of the visit? They should know exactly how long their visit will last, the expected number of sessions. Certainly, if they're having their services paid for by insurance and insurance limits the number of visits, you want to make sure they know that upfront. And the policy for missing appointments. Are there any fees associated with no-shows? And really, you'll want to discuss your financial arrangements in general. So if they're paying out of pocket, how much is each session? If they're using insurance, what is their copay? You'll want to give them information on your qualifications as a helper. What degree do you hold? What license do you hold? What types of experiences do you have? You also want to discuss things like the risk and benefits of alternative treatments. So if there's something else that can be used, let's say they're coming in for counseling for depression, you may also want to tell them that medication is an alternative treatment or an adjunctive treatment, meaning that can be used with therapy, and what are the risks and benefits of those treatments. You'll talk about the limits of confidentiality. Never tell a client that everything you say here will be kept confidential, because that is not necessarily true. And we'll talk about the limits of confidentiality in the next slide. You'll want to tell them about the records preservation and release policy. How will their records be kept and stored? What needs to happen in order for you to release their records to them or to someone else? What happens to their records in case of you passing away? And you should have a professional will and have a plan for who takes over, who takes possession of your records should something happen to you. You'll want to tell them about the involvement of third-party payers. So if their sessions are being paid for by some third party, like an insurance company, what information is going to be released to that insurance company? You'll tell them the procedure for resolving any disputes or complaints. You'll want to give them your licensing body information. So if they have some complaint against you, they'll know where to file that complaint. And then also emergency procedures. So what happens in case of them being in an emergency situation? How do they get in contact with you? And let me actually go back to this. You'll want to make sure that when you do your informed consent, it is a conversation that you have with the client. You don't simply give them a form and have them sign it, and that is the end of informed consent. You want to make sure they understand and fully understand everything on the form. Because often, either number one, clients won't read it fully, or they'll read it and think they understand it. And then once you start discussing things with them, it'll be clear that they don't quite understand all the nuances of informed consent. So make sure you do have a conversation, you allow them the chance to ask any questions they have, and you revisit this throughout your therapy session, particularly the limits of confidentiality, because often at the outset, they'll understand there are certain limits, that there are certain situations in which you can't keep information confidential, and they'll forget that over the course of therapy, especially if you're working with them for a long time. And then they'll say something that you'll have to break confidentiality for, and then when you tell them you're going to have to break it, they're surprised and they feel betrayed. So you want to make sure that you're reminding them about the limits of confidentiality. So when are you able to, or when do you have to break confidentiality? First is with the consent of the client or legally authorized surrogate. So the client can always consent for the release of information about themselves, the release of their notes and their documentation, but also a legally authorized surrogate. So know the laws for your state. Typically, parents have the right to access the documents of their children and to get information from you about what goes on in the therapy sessions with their children. So any legally authorized surrogate can get confidential information about the client. A court order. So the court can subpoena information and subpoena your records, and you'll have to release those. Continued treatment. So you can break confidentiality to give an insurance company information. If they are reimbursing for the services and they need information about the client's care, you would release that information to them. Also, other professionals who are involved in the client's treatment and care. You are required by law to report abuse of a child, abuse or neglect of a child, an elderly person, or a disabled adult. So this is required by law. This is not a situation where you can determine whether or not you break confidentiality for this. You would also break confidentiality for threat of harm to self or others. So if the client is threatening and you judge it to be a legitimate threat, threatening to harm themselves or threatening to harm someone else, you would need to break confidentiality for that reason. So again, make sure that your client thoroughly understands this and revisit it throughout your work with them. So how do you document your interactions with clients? You must keep timely and accurate records of your work with clients. And this is for three main reasons. First of all, fiscal reasons. You need to justify any money that you're charging the client and any money that you're charging an insurance company. It's important for clinical reasons that you have documentation. You'll need to refer back to your work with the client and see what kind of progress you've made. If that client were to go to a different clinician, they're going to need some documentation of your work with that client. And third of all, for legal reasons, you want to be able to document that you have followed the law, you have followed your ethical standards, should that come into question. Every contact that you have with the client should be documented, be that a phone call, a face-to-face visit, an email, a telehealth visit. Everything should be documented. And in that documentation, you want to avoid labels, jargon, and inferences. So this means that rather than say the client was suicidal, because that's applying a label, you would say something more objective like the client stated that they've recently been thinking of taking their own life. So that's something the client directly said, not your inferences about something the client said. So you want to be as objective as possible. Rather than saying something like the client seemed sad, you might say the client was tearful. The client often looked down at the floor and avoided eye contact. So things that are objective, you can observe. So it's clear what you actually saw as opposed to your interpretation of what you saw. The treatment notes should be brief and highlight only major activities of each session and client progress. So, for your own sake and your time, you want to keep them brief, but you have to hit upon the major activities, the major points, but they shouldn't be, lengthy novels, lengthy, in-depth descriptions of what goes on with you and the client. Because you have to remember that these records could be subpoenaed, these records could be requested by the insurance company, and you don't want to give unnecessary information. And if the client discusses someone else, you don't give that person's identifying information. So let's say, your client is having an affair with a coworker. You will simply say, client reports a relationship with a coworker. You wouldn't want to say, client's having an affair with John Jones from accounting, because should those records be subpoenaed, you don't want to expose information about somebody else. So you don't give identifying information about anybody other than your client. So what should your progress notes contain? So the session number, so meaning how many times have you seen this client, what time did the session start and stop, what diagnostic code did you apply to the client? Because if you're being reimbursed by insurance, you're going to have to give a diagnosis, and that diagnosis is going to have a particular code. And then a procedure code. So what are you actually doing in that session? Is it a 1 hour individual therapy session? That's going to have a procedure code. Is it 2 hour family therapy session? Is it an hour of cognitive assessment? So each of these various procedures will have a code that will need to be in your documentation. You'll document relevant assessment. So any formal or informal assessments you administer to the client. Their current status, so some current assessment of their functioning or their status. Dangerousness, are they reporting any suicidal or homicidal behavior or displaying anything that you take to be indicative of that? Any current stressors, and progress toward the treatment goals. You also want to include in your documentation any interventions that you use, your plan. So what is your next step in working with the client? What do you plan to do going forward? Any assignments that you give them. So any homework, anything that needs to be done outside of the session. You'll have your signature as a clinician. If you're under supervision, you'll have your supervisor sign, and also note if you did any consultation on this case, if you work with any other peer on this particular case. And your laws will vary by state with regard to record retention. So how long do you need to keep your records will depend on the state. So when documenting, keep in mind that your records may be subpoenaed. So the courts may ask for your records in a legal setting. The client may need treatment at a time when you are sick or away. So if you don't have good documentation, you're on vacation or you become sick or, God forbid you pass away, you need to make sure that you have notes in place or documentation in place that will allow the person who takes over that client's care to continue to progress in their care. The client may read your records. So your client is going to, well, could very well possibly request their own records. So when you're taking notes or you're documenting, make sure that whatever you say that you would be okay with the client reading. Your accuracy is compromised if you wait more than a day to complete notes. So you should always complete notes within a day of seeing a client. Ideally, you should do it either within the session or right after the session to make sure that your notes are accurate. Your record should be the best possible record of your professional judgment. So when looking at your documentation, it should be clear why you made certain decisions. So if I choose to terminate with the client, it should be clear that I arrived at this decision to terminate by documenting their progress and showing that they have met all of the goals that we set out at the beginning of therapy. So it's clear that it's time to terminate, or it's time to terminate because I've been documenting their progress and I've tried different interventions and they're failing to progress. So now it's clear that I should terminate. So it should reflect your professional judgment and why you made certain decisions. Nothing is considered a professional service until you've entered it into the record. So you can't simply say, well, I called you 5 times to schedule an appointment and you never answered. If that is not documented somewhere, the assumption is going to be that the client called you and you never returned their call. So make sure that you document every interaction. And also keep in mind that your record may be selected for audit to verify legally reimbursable services. So the insurance company may also audit your records to make sure that you were seeking reimbursement legally. So let's say that you use your billing software and billed for a service, but you don't have that document in the client's record. That would be considered you getting reimbursed for a service that you didn't provide simply because it was not documented, even if you actually did see the client for that service. So make sure that every contact is documented in a timely, accurate fashion.